Let's begin on Capitol Hill, where the House committee probing the January 6th Capitol riot has issued 10 new subpoenas for former Trump advisors, the most notable being former White House press secretary Kayleigh McEnany and senior advisor to the former president, Stephen Miller. The committee accuses both of spreading false information about the 2020 election. Earlier this week, the committee demanded records and testimony from former National Security Advisor Michael Flynn and Trump attorney John Eastman. The former president is urging his allies, such as political strategist Steve Bannon, to defy those subpoenas. Joining us now from the Hill with more is Chris Van Cleve. So, Chris, has the Justice Department given any indication on whether they will prosecute in order to enforce the panel's subpoenas? How important is it that they do so?
So the Justice Department has indicated that they are reviewing the criminal referral from the House of Representatives to hold Steve Bannon in contempt of court. That happened about 3 weeks ago, but no final decision has been made there. If you're a member of the House committee, you would say it's important the Justice Department take action against Steve Bannon.
Hey everyone, Dr. John here. Welcome. So what just happened, guys? The principle is simple and absolute. No one is above the law. A congressional subpoena isn't an invitation to negotiate. It's a command backed by centuries of legal tradition that escalates from contempt findings to financial penalties to arrest warrants to armed federal agents. The path exists precisely to ensure court orders have real teeth
And pursue charges in order to uphold the sanctity, if you will, of a subpoena from Congress. You can't defy congressional subpoenas. Certainly the committee would like to see the DOJ send a message that if you do defy a subpoena, you will face criminal charges. So, that's sort of the argument here. Congress has this oversight authority. They have the ability to issue subpoenas. The question is, will they be backed up with the teeth that can go along with a subpoena if you try to defy it?
Meantime, as we've reported, a federal judge has denied the former President Donald Trump's request to withhold White House records from the panel. Committee member and Wyoming Republican Liz Cheney addressed this while speaking at a fundraiser in New Hampshire this week. Here's what she said.
And at this moment, when it matters most, we are also confronting a domestic threat that we've never faced before. A former president who's attempting to unravel the foundations of our constitutional republic.
The United States Marshals Service exists for precisely this purpose. They are the enforcement arm of the federal judiciary, the mechanism through which the third branch demonstrates that its rulings carry consequences beyond stern language and disappointed press releases. When a judge issues a bench warrant, the marshals are the people who show up at the door. When a court orders the seizure of assets to satisfy a judgment, the marshals are the ones who execute the writ.
So Donald Trump's lawyers have already filed an appeal on this. But in the judge's ruling, she also addressed the question of Trump's ability to assert executive privilege. What exactly did the judge say regarding this?
Yeah, so the judge wrote, "Presidents are not kings, and plaintiff," meaning Mr. Trump, "is not president." The decision continued, "This is a dispute between a former and incumbent president, and the Supreme Court has already made clear the incumbent's view is accorded greater weight." Basically, the sitting president has more of a say on what is executive privilege and what it covers than a former president.
So the National Archives, Chris, is set to turn over former President Trump's White House records by Friday. But as Anne-Marie noted, the president and his lawyers filed notice to appeal the judge's ruling. Could this stop this document transfer from taking place on Friday?
When someone decides that their political significance places them beyond the reach of ordinary legal compulsion, the marshals are the institutional answer to that delusion. They represent the point at which the legal system stops asking nicely and starts insisting. Donald Trump has spent years treating this entire apparatus as though it were designed for other people.
Absolutely. An appeals court could issue a temporary injunction. They could issue a quick ruling. But it certainly is within the power of an appellate court to pause the document release process. An appellate court could very quickly greenlight it as well, and then you might see yet another appeal, to this one all the way to the Supreme Court. If you're the Trump team, your goal is to stop or delay this document release process as long as possible. But we're talking about hundreds of pages of documents from the Trump-era White House that could be released Friday afternoon unless there is an order to stop it.
So I want to ask you about something else. A watchdog probe just released a report yesterday and found that more than a dozen high-level Trump administration officials violated the Hatch Act, saying that they improperly used their official government powers to try and influence the 2020 election, essentially campaigning. What can you tell us about this report, and what does it mean? Will there be any consequences?
His relationship with subpoenas has followed a pattern so consistent and so thoroughly documented that it constitutes a recognizable strategy rather than a series of isolated decisions. When the legal system demands his compliance, he delays. When delay proves insufficient, he sues. When the lawsuits fail on their merits, he stonewalls anyway. When the stonewalling produces adverse rulings, he attacks the legitimacy of the institutions issuing those rulings.
So the Hatch Act is a 90-year-old or so law, 1939, that basically says folks in government office can't campaign, can't do certain political campaigning as part of their official functions. And what the Office of Special Counsel found was that you had 13 former Trump officials who appeared to violate the Hatch Act. 11 of those were in examples of live TV interviews. So somebody perhaps speaking as their position as an advisor to the president, but actually talking about the campaign. And then 2 other instances that dealt with the Republican National Convention. And these are sort of a who's who of the Trump administration. Secretary of State Mike Pompeo, Kellyanne Conway, Jared Kushner, Stephen Miller. So a long list of Trump officials that may have violated the Hatch Act. I think at the end of the day, as far as Main Street is concerned, this is a violation of when you can campaign and how you can campaign in an election that's already happened, and the people have spoken, and Mr. Trump wasn't reelected.
And through all of this, he has placed a wager on the proposition that the institutional friction created by his political significance will prevent the legal ladder from being climbed all the way to its highest rung. He is betting that the Marshals will not actually arrive, that the confrontation will never become physical, that the system's reluctance to escalate against someone of his stature will provide sufficient protection to make defiance operationally successful.
So in other news, Chris, we're also learning about the disturbing threats made against Republican lawmakers who supported President Biden's infrastructure bill. Congressman Fred Upton of Michigan is one of them. He claims this started after a House colleague tweeted the names and office phone numbers of several colleagues. Who's he referencing, and do we know if any others have received similar threats?
Well, lawmakers are receiving threats at a record rate. We know more than 9,000 threats against lawmakers have come in this year, and that's thousands above past years. That's part of the, this new normal almost for elected officials on all sides of both sides of the aisle here are seeing a significant increase in threats, and that's certainly had ramped up during the election and since January 6th. Mr. Upton received a voicemail that he played that was profanity laced. That
even when it is legally unjustified. Let me be completely direct with you, because this channel exists to provide clarity rather than confusion. The specific scene of United States Marshals physically arriving at a Trump property to enforce a subpoena through direct confrontation has not occurred. The online ecosystem contains numerous videos depicting such scenarios.
Basically wish death on him and his family. He says that call and hundreds of others came after Marjorie Taylor Greene, the representative from Georgia, a Republican, tweeted out a list of the 13 Republicans who voted for the infrastructure bill in the House with their office phone numbers. Congresswoman Greene says that she herself receives death threats and that she's certainly not encouraging or condoning that behavior, but she does believe it is appropriate for taxpayers to, quote, politely let elected officials know how they feel about their votes. I think when we're talking about this infrastructure bill, it's important to note that in the Senate, it passed with wide bipartisan support. You saw Mitch McConnell voting for it. The deal was crafted by 5 Republicans and 5 Democrats. This was not really a one-party bill. And in fact saw far more Republican support in the Senate than it got in the House. But you are seeing lawmakers on a daily basis receiving threats, and certainly when there's been a contentious vote, you see more of that. Just this week, we've been talking about Representative Paul Gosar of Arizona, who apparently manipulated like an anime cartoon that depicted violence against AOC and perhaps President Biden. So there is a heated rhetoric here that continues and is translating to real-world threats against lawmakers.
Dramatizations that imagine what would happen if the legal system escalated from the paper demands that Trump has defied to the physical enforcement mechanisms that those defiances have thus far avoided triggering. These videos are fictional works, explicitly labeled as dramatizations by their creators, and they should be understood as imaginative extensions of a real and serious legal conflict rather than as documentaries of actual events. But the foundation on which they are built is entirely real. The documented pattern of subpoena defiance is real. The legal mechanisms for escalating to physical enforcement are real. The marshals who would carry out that enforcement are real. And the question of why the ladder has not yet been climbed to its top, why the dramatized scenario remains dramatized rather than actualized, is one of the most important questions in the entire landscape of Trump's relationship with legal accountability. The most extensively documented example of this dynamic unfolded when the House Select Committee investigating the January 6th attack on the Capitol issued its subpoena to the former president. The committee was conducting the most significant congressional investigation in modern American history, examining an assault on the democratic process itself, an attempt to interrupt the peaceful transfer of power that had injured law enforcement officers and threatened the constitutional order. At the center of that investigation stood the man who had been president when the attack occurred, whose statements and actions and decisions on that day were essential to understanding what had happened and why. The committee demanded that he produce documents by a specific date and appear for sworn testimony shortly thereafter. These were not vague requests or open-ended invitations. They were specific commands backed by the full subpoena authority that the Constitution grants to the legislative branch in its oversight capacity. Trump did not produce the documents. He did not appear for the deposition. The committee publicly stated that he had failed to comply, that he had defied the subpoena, that he was treating a binding legal command as though it were a suggestion he was free to disregard. His response to the subpoena, rather than compliance, was a lawsuit seeking a court order to block its enforcement. The lawsuit advanced arguments about the limits of congressional authority over former presidents, claiming that no previous occupant of the office had ever been compelled to testify under congressional subpoena, and that the committee lacked the power to demand his appearance. Courts had previously rejected similar arguments about congressional subpoena authority when they were advanced by Trump's own administration. The broader legal record on whether former presidents enjoy blanket immunity from congressional testimony does not support the proposition that they can simply refuse to engage with legislative oversight. But the lawsuit served a function that went beyond its legal merits. It served as a mechanism for creating procedural friction, for introducing delay into a process that was operating under the time pressure of an approaching congressional session deadline. By the time the litigation had wound its way through the preliminary stages, by the time the courts had begun to address the substance of the legal arguments, the congressional session was drawing to a close, and the political circumstances had shifted in ways that allowed the defiance to effectively succeed. The committee never obtained Trump's testimony. The documents he was supposed to produce were never handed over. The legal process that was designed to compel compliance had been weaponized against itself. Its deliberateness and its procedural protections transformed into shields behind which a determined defendant could hide until the clock ran out. This was not a story about a subpoena being legally contested on good faith grounds with the intention of ultimately complying if the courts rejected the arguments. This was a story about using the legal system's own virtues, its patience, its fairness, its reluctance to escalate to physical confrontation as tools for evading the accountability that the subpoena was supposed to produce. The strategy worked, not because the legal arguments were strong, or because any court ultimately endorsed the claim that former presidents are immune from congressional subpoenas. The strategy worked because the friction created by the resistance was sufficient to prevent enforcement before the political window for enforcement closed. The formula is simple and devastating in its effectiveness. this, resistance plus friction plus time equals effective defiance. Delay the compliance long enough, file enough motions and enough appeals and enough procedural objections, and by the time the system is ready to impose consequences, the moment for meaningful accountability has passed. This is the core of the subpoena defiance pattern that Trump has deployed across multiple contexts, and it reveals a calculation about the relationship between legal obligation and political power that goes to the heart of whether the American legal system can actually deliver on its foundational promise that no one is above the law. The January 6th subpoena defiance did not occur in isolation. It was the most publicly visible example of a broader approach to congressional oversight that characterized Trump's entire first term and that has continued into his second. His administration directed multiple senior officials to defy congressional subpoenas, ordering them not to appear for scheduled testimony, instructing them not to produce requested documents, and signaling that engagement with legislative oversight would be treated as disloyalty rather than compliance with legal obligation. The arguments used to justify that stonewalling were repeatedly and emphatically rejected by courts that found the administration's claims of absolute immunity from congressional oversight to have no basis in law. But the operational effect of the stonewalling was to significantly limit what Congress was actually able to learn through its oversight mechanisms. Courts kept ruling that the legal arguments were wrong, and the administration kept filing new legal arguments. And by the time each successive argument was rejected, the political window for the specific oversight inquiry had narrowed in ways that diminished the practical value of the eventual legal victory. Congress won the legal battles and lost the information war. Civil liberties organizations documented this pattern extensively during the first term, cataloging the ways in which the administration's systematic defiance of congressional subpoenas represented an assault on the separation of powers itself. The Constitution grants Congress the authority to conduct oversight, to investigate the executive branch, to compel the production of information necessary for informed legislating. When the executive branch simply refuses to comply with that oversight, when it treats congressional subpoenas as optional requests that can be ignored without consequence, it effectively nullifies one of the central checks on executive power that the framers designed. The president becomes, in practice, if not in constitutional theory, immune from the legislative scrutiny that is supposed to prevent the accumulation of unchecked authority. The stonewalling strategy, repeatedly condemned by courts as legally baseless, has been operationally successful at achieving precisely that result. The legal ladder to enforcement exists and has been tested successfully in cases involving Trump's associates. When the January 6th committee subpoenaed Steve Bannon and he defied it, the system responded. He was indicted on contempt of Congress charges, a crime under federal law that carries the possibility of imprisonment. He was convicted by a jury of his peers after a trial in which the evidence of his willful noncompliance was presented and evaluated. He was sentenced to prison, and after exhausting his appeals, he reported to a federal correctional facility to serve that sentence. Peter Navarro followed the same path: defiance, indictment, conviction, sentencing, incarceration. Both of these men were Trump allies who presumably believed that their political connections and their proximity to power would shield them from the ultimate consequences of their defiance. Both of them ended up in federal prison because the legal system, when it decides to act, is capable of climbing the ladder all the way to its top. Their cases prove that the mechanism works. The escalation from subpoena to contempt to indictment to conviction to incarceration is not theoretical. It is a functional legal process that has produced real consequences for people who thought themselves protected by their association with political power. The question that their cases leave hanging is why the same ladder has not been climbed to the same conclusion with respect to Trump himself. The legal authority exists, the precedents exist, the enforcement mechanisms exist and have been demonstrated to function. What has been missing is not the legal tools, but the institutional will to apply those tools to someone whose political significance creates complications that Bannon and Navarro, for all their prominence, did not present. The reasons for that missing institutional will are not mysterious. Physically enforcing a court order against Trump means confronting the reality that he is is protected by the United States Secret Service, an armed federal agency whose agents are trained to protect their charges from threats. It means navigating the fact that he commands the passionate loyalty of tens of millions of voters who have already demonstrated a willingness to engage in political violence when they perceive their leader to be under attack. It means calculating the institutional costs of a confrontation between federal marshals and Secret Service agents, between the enforcement arm of the judiciary and the protective arm of the executive. It means weighing the risk of civil unrest, of political backlash, of historical consequences that extend far beyond the immediate legal question of whether a subpoena was properly complied with. These calculations are not irrational. The costs of physical enforcement against someone of Trump's stature are genuinely significant and genuinely different from the costs of enforcing against an ordinary citizen or even against a prominent media figure like Bannon. The system is designed to be cautious, to consider the broader implications of its actions, to avoid unnecessary confrontations that could escalate in unpredictable ways. But that very caution, that institutional reluctance to escalate to the highest rung of the legal ladder, is precisely the mechanism through which the defiance strategy achieves its objective. Trump's political significance creates friction around the enforcement process. That friction makes courts and law enforcement agencies and oversight bodies more hesitant to escalate. That hesitation allows the defiance to continue without the imposition of consequences sufficient to compel compliance. The defiance succeeds not because the legal arguments supporting it are valid, but because the institutional costs of overcoming it are high enough to deter the institutions from trying. The fictional ecosystem of videos depicting marshals arriving at Trump properties represents an imaginative engagement with the tension between what the legal system is designed to do and what it has so far been willing to do. These dramatizations take the documented reality of subpoena defiance, the established existence of the United States Marshals Service as the enforcement mechanism for federal court orders, and the specific precedents of Bannon and Navarro demonstrating that the ladder can be climbed, and they project forward to the moment when the institutional caution finally gives way to institutional resolve. They depict the scene that would occur if a judge issued a bench warrant for Trump's arrest in connection with subpoena defiance, and the marshals actually showed up to execute it. The confrontation between federal agents serving different branches of government, the legal and constitutional questions that would arise, the political explosion that would detonate across the country. These are dramatizations, not documentaries, but they are dramatizations of something that the legal system is specifically designed to do and that it has so far declined to do only because of the unique political complications of the defendant involved. The distinction between what has actually happened and what is being dramatically imagined is essential for anyone navigating the current media environment. The documented reality is serious enough on its own terms without needing to be embellished. Trump has defied congressional subpoenas. He has filed lawsuits to block their enforcement. He has instructed aides to stonewall oversight requests. He has treated the legal obligations imposed by subpoenas as optional inconveniences to be managed rather than binding commands to be obeyed. Courts have repeatedly rejected the legal arguments he has advanced to justify this defiance. His associates have gone to prison for similar defiance. The system has demonstrated that it possesses the tools to compel compliance and that it is willing to use those tools against people connected to Trump. The only remaining question is whether it will ever be willing to use them against Trump himself. The answer to that question depends on a series of institutional decisions that are inherently unpredictable. It depends on whether a judge somewhere, at some point, concludes that the costs of continued non-enforcement have become greater than the costs of enforcement. It depends on whether the accumulation of defiances across multiple contexts eventually triggers a response that follows the latter to its conclusion, regardless of the political complications. It depends on whether the foundational principle that no one is above the law is ultimately backed by the institutional will to demonstrate that principle through action rather than merely asserting it through rhetoric. The legal authority exists. The precedents exist. The marshals exist. The only missing ingredient is the decision to use them. The broader implications of this dynamic extend far beyond Trump himself. If the most politically significant figure in the country can successfully defy subpoenas without facing the ultimate enforcement mechanisms that the system is designed to deploy, then the precedent is established that the legal ladder is not for everyone. Future powerful people, of whatever party and whatever ideology, will have learned that political significance creates a de facto immunity from the most serious consequences of legal defiance. The subpoena power, which is one of the essential tools through which Congress exercises its oversight function and through which courts compel the production of evidence, will have been effectively nullified for anyone with sufficient resources and sufficient political support to make enforcement costly. The principle that no one is above the law will have been replaced in practice, if not in formal legal doctrine, by the principle that the law applies differently depending on who you are and how much disruption your defiance would cause. The January 6th committee subpoena sits at the center of this story because it represents the most significant accountability failure produced by the defiance strategy. The committee was investigating an attack on the peaceful transfer of presidential power, the most fundamental process in democratic governance. The person who was president when that attack occurred, whose words and actions were central to understanding why it happened and whether it could have been prevented, was subpoenaed to provide documents and testimony. He refused, he sued, he delayed, and by the time the legal process had played out, the congressional session had ended and the committee never obtained the information it sought from its most important witness. The most significant congressional investigation in modern history failed to compel the testimony of the person at its center because the combination of legal resources, procedural maneuvering, and institutional caution created enough friction to run out the clock before enforcement could be achieved. This is not a story about the legal system failing to recognize that defiance occurred. The committee publicly stated that Trump had defied its subpoena. This is a story about the legal system failing to impose consequences for that defiance in time for those consequences to produce compliance. The path forward is unclear, but the tools for clarity exist. Congress retains its contempt power and can refer defiant parties for criminal prosecution, as it did with Bannon and Navarro. Courts retain their contempt power and can impose escalating sanctions on parties who refuse to comply with their orders. The Marshals Service retains its enforcement authority and stands ready to execute the warrants and writs that courts issue. The mechanisms are all in place. What remains to be seen is whether the institutional will to use those mechanisms against someone whose defiance has been so effectively shielded by political significance will ever materialize. The dramatized videos imagine that moment of materialization, the point at which the system decides that enough is enough and that the principle of equal application of the law is worth the institutional costs of enforcing it. Whether those dramatizations ever become documentary footage is the question on which the future of American legal accountability depends. The foundational principle that no one is above the law has been tested before in American history. It has survived challenges from powerful interests and determined opponents, but it has rarely been tested by someone with the combination of resources, political support, and willingness to push every procedural boundary that Trump brings to the confrontation. The outcome of that test will determine not just the legal fate of one individual, but the credibility of the entire system of checks and balances that the Constitution designed to prevent the accumulation of unchecked power. If the system can enforce its commands against the most powerful person in the country, then the principle holds. If it cannot, then the principle was always more aspirational than operational, and everyone now knows it. The marshals waiting at the door are not a fictional construct. They are the embodiment of that principle, and the question of whether they will ever be asked to walk through is the most important unresolved question in the entire legal landscape.